Okay, good morning, everyone, and welcome to part 3 of AMAC Foundation's online seminar on women and Social Security. This is the third of 4 parts in our series that's designed to acquaint women with some of the most important facets of Social Security and to provide the information they need to make the decisions that are most appropriate to their situation. Just like last week, though, we're going to begin by reviewing our official legal notice, the statement that further defines the information we provide. So I'll just read that quickly. The views presented today are provided by the AMAC Foundation Social Security Advisors, certified by the National Social Security Association, LLC. They do not necessarily represent the views of the Social Security Administration. The information presented today does not constitute financial, legal, or tax advice and should be used for informational purposes only. Since individual circumstances vary, you should consult your legal, tax, or financial advisors before making any financial decision. And finally, AMAC Foundation is not affiliated with or endorsed by the Social Security Administration or any other governmental agency. So, with that out of the way, I'd like again to welcome you to the third part of our seminar, where we're focusing on topics of particular importance to women. Last week, we covered a collection of very detailed topics. Those topics that are related to retirement benefits for single women, spousal benefits, and the complicated restricted application and deemed filing rules that Social Security administers. We also covered benefits available to widows and divorcees, and we closed with a brief discussion on common law and civil union arrangements. It was a pretty long and tedious session, and the myriad rules and details about Social Security are very complex. And if you weren't able to join us, or if you just want to review that material again, you can watch it on our website, amacfoundation.org/videos. The first session is also available at this same location, and this session today will be recorded and uploaded later on today. So I'd like to introduce my colleague. Again, I'm Jerry Hayford with the AMAC Foundation, and my colleague with me today is Sharon Kletchka. Sharon is a 20-year veteran of accounting and administrative details, and she's done a lot of tax work and has a lot of in-depth experience in areas related to Social Security. And she is probably the most gifted person I know in terms of understanding Social Security details. And I'm pleased to have the opportunity to work with her, and I'm looking forward to this session as well. In this third part of our program, we're going to focus on specific types. Hold on a second. Specific topics that are related to benefits. We're going to talk about benefits that are available to children, adult disabled children, adopted children, and stepchildren. We're also going to examine the benefits that are available for dependent parents, and we'll get into the topic of disability benefits also, another very complex area of Social Security. We'll close out the session with a discussion of this thing called the family maximum, and that's the maximum monthly amount that can be paid on a worker's earnings record under Social Security. And you'll see how that's calculated and how when the benefits get stacked up, how it affects what's available to a total family on a worker's record. So, I want to get into it then, and I'm going to ask Sharon to begin by discussing the benefits that are available to children in the event that their parent retires, dies, or becomes disabled. In these situations, Social Security offers benefits that can help them cope. So it's not uncommon for grandparents to have adopted children. If you're an older parent or have adopted a grandchild and they are not yet 18 or 19 and still in school, they are eligible for Social Security benefits equal to 50% of your full retirement benefit, regardless of when you take your benefits. If you adopt a child or children already receiving benefits, you must notify Social Security when that happens. The child's or the children's benefits will continue uninterrupted. Sharon, why don't you give us an example of how that actually works?
Well, where these come into play is, say, for instance, there's young children and their parent are killed in an accident. Car accidents, plane accidents, unfortunately do happen. This provision makes it easier to provide financial system to to other family members to be able to afford to keep these children in the family.
Okay, moving on to benefits for adult disabled children. This tends to be a very complicated area too, so I'm going to ask Sharon to talk about how a disabled adult child is handled under Social Security.
A disabled adult child of a retired, disabled, or deceased wage earner may also receive benefits on the account of a parent if the disability began before the child became 22 years old. Also, once a disabled child turns 18, they can apply for SSI because the parent's income and assets are no longer taken into consideration. The child is found disabled using the same definition of disability that applies to all the disability programs operated by the Social Security Administration, except for children's SSI. When a parent retires or becomes disabled, the adult child then applies for disabled adult child benefits on the parent's account. Because the child was found disabled and has been receiving SSI since before the age of 22, Social Security Administration adopts the earlier decision that the child is disabled.
Okay, very, very complex rule-based issue. Continuing on the discussion, of disabilities and how they affect people, child benefits and how they affect people. Let's shift gears a little bit to talk about benefits for dependent parents. Totally different subject, but let's get into that a little bit, a parent's benefit.
Now, the parents' benefits are not well known or commonly used because they do affect family maximum, which we will be covering later on in the seminar. But a parent's benefit is a survivor benefit for a parent who was financially dependent upon their now deceased child. To receive parents' benefits, you must be at least 62. You must have a dependent on your child at the time of their death. You must have received at least 1/2 of your support from the deceased worker, and you have not remarried after deceased worker's death. It's okay if you're married at the time of death. No proof of support with the Social Security Administration within the required time limit, and you are not getting a higher Social Security retirement payment. One parent is entitled to 82.5% of the deceased retirement benefit, and both parents are entitled to 75% each. To meet the contributing 50% of support requirement, the deceased child must have been making regular contributions for the parent's ordinary living costs, and those contributions equaled or exceeded 50% of the parent's ordinary living cost, and the parent's income from sources other than the child that is available for support is 50% or less of the parent's ordinary living costs.
Sharon, we talked about the time limit of filing proof of support. Do we know what that is offhand? Or is that something you would have to call Social Security about? I know there is a time limit on that of when you have to provide that information.
I would have to find out how long that is.
Okay. Moving into Social Security disability, another complex area. There are some general rules, And I'll ask Sharon, because I know Sharon has a lot of knowledge and a lot of experience in this area. I'll ask her to cover the general rules first, and then we'll get into some more of the details.
Okay, if you should become unable to work due to your health or physical capabilities, you may qualify for Social Security Disability, SSDI. The condition has to be expected to last at least 12 months or result in death. Age is not a factor in determining the size of the disability benefit. With the disability benefit, the year you become disabled is considered the year that you reach your full retirement age in terms of paying benefits, meaning fewer years can be used to calculate the amount of your benefit. Years of low or no earnings are not included when your disability benefit is calculated. And your disability benefit amount is shown on your Social Security record if you are younger than your retirement age. You will probably notice the amount of disability benefits you would receive are higher than your estimated retirement benefit. To receive a disability benefit, you must qualify on your own work record. If you become disabled and do not qualify for a benefit on your own work record, unless you qualify for supplemental Social Security income, known as SSI, you will not be eligible for a Social Security benefit until you become eligible for a spousal benefit or widow benefit.
It's an interesting point in calculating the amount of a disability benefit. You had mentioned that years of low or no earnings are not included when your disability benefit is calculated. So that really is different from calculating a retirement benefit, because retirement benefits, unfortunately, low years are included. So you're actually getting a benefit by discounting those no or low income years.
Correct, where in the regular Social Security calculation, it's based on 35 years, and when you don't have 35 years, they'll add zeros to make 35 years, which reduces the benefit. On the disability, they don't count the years you didn't work.
Yeah, so that's the reason why those numbers would appear different on your Social Security statement. And that's an interesting twist in Social Security. Moving into some of the more detailed rules of Social Security disability. Sharon, let's talk about how you qualify for disability.
Well, as with retirement benefits, the maximum number of work credits needed to be fully insured is 40. An individual is said to be fully insured if they have earned 40 work credits. And to receive a disability benefit, you also have to have worked at least 5 years out of the last 10 years before you become disabled. As it is an insurance plan, you can actually lose your eligibility for disability benefits, even though you still qualify for your Social Security benefits. Now, disability benefits are available up to your full retirement age. And if you are already at least 62 when you become disabled, and you then have the option to file for disability and your reduced retirement benefit at the same time. This way you can receive your reduced retirement benefit while your disability case is pending. Then, if and when your disability is approved, your benefit will increase to 100% of your retirement benefit. Then when you reach your full retirement age, your disability benefit automatically converts to your retirement benefit, and you will not have any change in the amount you receive.
And it's surprising the number of people that have difficulty understanding that. We get a lot of questions about that, the timing of disability versus full retirement. So that's an interesting area. And some more on disability, the details of disability.
If you should become disabled after you've already started receiving your retirement benefits, but you are not yet your full retirement age, you do still have the option to file for disability benefits. And if you are successful in winning your case, you will receive the higher disability benefit. But in this instance, Your benefit will be reduced by the amount your retirement benefit is reduced for the months prior to the month of eligibility to the disability benefit in which you received retirement benefits. Simply put, if you took your benefits at 62 and became disabled at 64, your disability benefit would be the amount of what your retirement benefit would have been if you took it at 64.
Let's explore that a little bit further. How about a situation, Sharon, where you took your disability benefits at 62 and subsequently, well, let's say you had a disability case pending when you turned 62, and you didn't know the outcome of that disability case, and so you filed for Social Security benefits at age 62, which would subject them to a severe reduction. And then, subsequent to that, you're now on retirement benefits early, and they've been reduced, and now your disability pending case is approved, and you're on disability. What happens to your benefit at that point?
As you had previously applied for disability, what if you win your case, even though you filed for your retirement benefits at 62, you will receive 100% of your full retirement age benefit because you applied for disability ahead of early retirement.
Yep, and it's a date controlled situation, and it makes a radical difference in the amount of your benefit ultimately, if your case is approved. If your case is not approved, then you stay on a reduced retirement benefit.
Right, so you have to, when making that decision, determine, can you survive on that reduced benefit? Because should you lose your case, it will stay permanently reduced.
Lots of good things to consider. Okay. More details on qualifications for disability.
If you are married or divorced and meet all the requirements and your spousal benefit would be higher than your disability benefit, you can apply as early as 62 for your spousal benefit. But if you switch benefits before your full retirement age, they will be permanently reduced. As disability benefits are not affected by the deemed filing rule, you have the option to delay taking your spousal benefit until your full retirement age to receive the full 50% of your spouse's or ex-spouse's benefit.
Yep, that's another key point to keep in mind. And now let's explore quickly the situation where the disability applicant is under age 31.
The requirements for disability insured status are somewhat different for persons younger than age 31. As with retirement benefits, you must have accumulated a certain number of work credits before you can qualify for SSDI disability benefits. However, fewer credits are required to qualify for the disability program than for retirement. You can earn up to 4 credits per year of employment. And how many credits you need to qualify for disability depends on the age you become disabled. Before age 24, you may qualify if you have 6 credits earned in the 3-year period ending before your disability starts. For age 24 to 31, you may qualify if you have credit for having worked half the time between age 21 and the time you became disabled. For example, if you become disabled at age 27, you would need credit for 3 years of work, 12 credits, out of the previous 6 years between age 21 and age 27.
I'm just wondering, I'm just curious, I guess, off the beaten path on this is, what are those age brackets, how are those age brackets actually determined? Like what's the significance of 31 years old? Do you know, offhand? I really don't know. I've seen those age brackets, but I've often wondered how they're calculated and what they mean.
Well, it wouldn't be uncommon for someone that young, especially if they went to college, to have many years of work. So their benefits probably being based maybe only on 3 years of employment
Yeah.
to get them as the highest benefit as possible.
Yeah, there could be some arbitrariness to it also. I don't know. We'd have to research that to figure that out. But not really important for what we're talking about today. Okay. Moving into this thing called the family maximum. That's a fascinating area, and there's a lot of math behind this. So this is one of Sharon's really detailed knowledge areas.
Well, the Family Max is one of the most complicated parts of Social Security there is, because there's so many different things that affect it. And we're not going to teach you how to calculate it today, because we'd be here for a while and you probably would have a bunch of questions. But I'm going to begin with something that I'm taking. It's quoted directly from the Social Security website. Social Security's family maximum rules limit the total benefits payable to a beneficiary's family. Different family maximum rules apply to retirement and survivor benefits than to disability benefits. The rules for calculating family maximum benefits are complicated. In some particularly complex cases, it is difficult to properly implement the family maximum, which can result in over or under payments.
I find that statement from Social Security particularly fascinating, because basically what they're saying is they could easily make a mistake because of the complication of the process.
It's
interesting to me that they would actually note that in writing in their policy manuals.
Yeah. And what you're looking at on the screen on this particular slide is how they calculate the family maximum for 2018. There's quite a few steps involved. This is based on a retirement or survivor benefit.
It's similar in concept to the calculation of a PIA based on average index monthly earnings. It's just that there's an additional tier there, and it just becomes awfully complicated. And I think that as Social Security has acknowledged in their statement, they do tend to make mistakes in this area.
And the reason that happens is because for the regular calculations where you're just based on one person's record, they have actual software. But when you get into the more complicated family maximums, they have to do them by hand. And that's how the mistakes happen.
Yep. Let's talk a little bit about disability, how disability benefits factor into the family maximum.
Well, disability benefits are the disabled family maximum benefits affects many more families and a wider range of family sizes than the retirement and survivor family maximum, because more restrictive rules apply to disability benefits. To begin with, the family maximum for a disabled worker is based on 85% of the worker's aim. And it cannot be more than 100% or less than 100% of the worker's PIA. And the disabled worker always receives 100% of their benefit before paying any benefits to dependents. And with disability beneficiary families, you can sometimes lose all of their auxiliary benefits, even in cases where only one family member qualifies. all disability families with 3 or more beneficiaries are affected by the family maximum, and more than half of families with 2 beneficiaries are affected. I mean, unfortunately, even if someone should qualify for disability benefits on their record, their family may not qualify for auxiliary benefits.
That is a wildly complicated area, and we do get a fair number of questions in our Social Security Advisory Service about that, and sometimes when we're handling an inquiry, we need to remind people about there's an impact on the family maximum that you need to consider. So it's a difficult area to understand sometimes. Just a couple of more rules on the family maximum. What we just talked about applies to retirement and survivors and Social Security disability situations, but there are a couple of more complications.
Most family maximum cases follow the standard family maximum rules that apply to retirement and disability cases. There are also additional rules that apply to more complicated situations. Social Security uses an automatic system to check standard family maximum cases. The incorrect payments generally occur because the more complicated cases are calculated manually, such as duly entitled spouses. For example, individuals receiving both a worker's benefit and a partial spousal benefit, child and care benefits, or combined family maximum cases. Duly entitled beneficiaries are entitled to a worker's benefit based on their own earnings, as well as auxiliary benefits based on someone else's earnings. In dual entitlement cases, where the auxiliary benefit is higher than the worker's benefit, the total benefit is the same amount as the full auxiliary benefit. For these duly entitled beneficiaries, the family maximum only applies to the auxiliary portion of the benefit.
Absolutely.
And I'm sure you want me to explain that a little bit.
Yeah.
What happens there is when you have the instance where the spouse is entitled to a spousal boost, a spousal benefit, in addition to her own retirement benefit. But children come into the picture. Adopted grandchildren, adult disabled children. Then that spousal benefit is limited to the family max, and it could be reduced to provide benefits to the children.
Let's talk a little bit now about the combined family maximum, again, defining that a little bit further.
Okay, the combined family maximum is used when a person qualifies for auxiliary benefits on more than one worker's record. The combined family maximum is the sum of the family maximums established for each worker, but it does not exceed the statutory upper limits for the combined family maximums. For cases in which a beneficiary qualifies for benefits on multiple records, his or her benefits are determined based on the work record of the worker that will yield the highest benefit amount. However, the family maximum amount is determined based on the sum of the family maximums established for each worker's record. And how that works out, once again, if you have a case where there's children, they could actually receive a higher benefit than they would normally receive just on the one worker's record because the family maximum's been increased.
Yeah. Okay, a lot of complexities here in this whole dependents benefits area, and that really concludes part 3 of our 4-part seminar. we look forward to seeing you again next week for the fourth and final portion of this seminar. And as we've done since the beginning, all of these sessions are recorded and available on our website, including this one, if you want to go back and just kind of re-listen to what we just discussed because of its complexities. Sometimes the second time through it makes a little bit more sense. Next week, for part 4, our concluding session, we're going to cover Social Security's absolutely fascinating windfall elimination provision, which we refer to as WEP, and the government pension offset, which we refer to as GPO. And we're going to talk about the rules that govern those two provisions of the Social Security system and how they impact benefits to retirees. We're also going to get into the always interesting issue of how and when your Social Security benefits are subjected to federal income tax. This is frequently a very lively area for people that are calling into our advisory service, particularly if they did not factor that into their financial planning and all of a sudden are surprised to find out that as much as 85% of their Social Security benefit is subject to income tax at their marginal rate. Then it really, if you haven't considered that in your planning, that's a pretty big hit. We're also going to talk about Social Security's lump sum payment provision for deceased beneficiaries, that $255 payment, and how that's administered. And we're also going to cover some of the basic rules governing folks living outside of the United States. There are some things that need to be understood about that in terms of getting your benefits offshore. And we're going to conclude the fourth and final week with a discussion of Medicare and how it intersects with Social Security, and particularly the hold harmless provision. And the hold harmless provision generated a lot of discussion the past couple of years because of the low COLA adjustments and how that has impacted that. So that's caused a lot of questions to our advisory service. So we'll cover that as well. And again, a reminder, these sessions are all recorded and available on our website. And we have the chat room open now, so we'll just kind of hang out here for a little while, a couple minutes. If you have any questions, feel free to submit them and we'll respond to them. But once again, we will see you next Tuesday morning, July 10th, same time, same place. And we will wrap up our 4-part seminar. So any questions at all, just feel free to fire them away. And in the meantime, know that our Social Security Advisory Service is available to anyone that has a particular question about their situation. We're still handling probably in the range of 500 a month, so it's become a very active area for us. So one final time, any questions? And if not, then we will close our session and we'll see you next Tuesday at 10 o'clock. Thank you very much.